Question number 1.
Lordship, in terms of the last order, we were supposed to bring on record the letter from the Lordship companies, Lordship. We have.
In terms of the earlier order, the original letter of instruction from the appellant addressed to Mr. Gustav Paul Senior Advocate, representing the writ appellant.
May I please, Major?
Yes. Yes.
May I please, my lord? The petitioner, appellant herein is an enrolled person in the Assam Rifles. He was issued a show cause notice by the respondent for having incurred 5 red ink entries. And that is Annexure 1. Annexure 1, page 19 to 21. Herein, the offences are detailed herein, and punishment awarded was also mentioned herein. The allegation was that he was granted leave, and in availing leave, he has overstayed without sufficient cause. The first one was for
How many days unauthorized leave?
Yeah.
How many days unauthorized leave?
On 5 occasions, there are different days. On first occasion, he has availed of 76 days. No. First occasion. That is which constitute an offence under Assam Rifles Act 2006 within bracket 26B. That is number 1, for which he was awarded punishment by the authority. Then he has overstayed for 7 days on second occasion. That is page 19. Then on page 20. Again, on third occasion, he was absent for 63 days. And on fourth occasion, there are only 6 days.
There were 5 red ink entries.
5, Lordship.
So this is a discipline force. How we can look into this? This is for them to run the administration.
Lordship.
The discipline, if a person suddenly doesn't come
Lordship.
and then he doesn't report,
Lordship.
So this is the sixth instance.
Lordship, I may be hard to this section. He is a resident of UP, Uttar Pradesh, in a village, Mathura.
Maybe. Has he asked for leave
Lord.
on all the 5 occasions?
Lordship.
Did he ask for leave in all the
After
5?
leave. I was granted leave, and thereafter I overstayed.
It's overstay of leave, my lord.
Overstayed, all are overstayed.
My lord, for example, he took leave for 10 days, my lord. He comes back after 85 days.
Not 85, not on.
Yes, first case he's absent
First
for 75
one-
days, my lord. Second
What?
case 7 days.
75
Then
days.
63 days
No,
again.
but has he given any justification for this?
There's no justice. He's only saying there is only sole earning member. That is only justification.
And
How many years left for his service?
He has been granted pensionary benefits, my lord.
The granted pension benefits.
The order itself says, my lord, the improved order.
And Lordship, on 4th and 5th, on 4th occasion, he overstayed for 6 days, and on
But that is not said in the judgment.
Lordship,
What is the letter of discharge?
yes,
Page 114, my lord. There's a paper book, my lord, in
114.
114. In the paper book, in the memo of appeal, it is. Lordship has a paper book.
118 you said, no?
114 in the paper book. In the main memo of appeal, it is 132. my lord.
In the main memo, it's page
132.
132. So what is the final order? So he's the same thing. I'm looking at it. Same thing. It's 13 March 2023.
Yes, my lord.
Oh, so he's discharged, but why you say
Last sentence, para 4, last sentence, my lord. I also direct that number so and so.
there are 4?
Para 4, the last sentence, my lord.
No, it's not. I think we are looking at different paper. 4. Just show us that particular thing. Para 4.
At page 114.
Oh. I therefore by virtue of all others available and all other pension is given. So he has completed pensionable service.
Yes, my lord. He joined in 2012, my lord. He completed more than 10 years of service,
2012 he joined.
my lord.
So what is wrong with the order?
let's see. I would like to refer Regulation 108.
108.
108, 108.
Where will get it? Page?
Discharge on ground of reading and teach. And our cases of this nature.
108.
108. Discharge on ground of reading and teach.
108 of the paper?
Regulation, Lordship,
No, where will get it? Where can I get it?
2016.
No, where we can find it?
Do you have a copy? Please give a copy.
one copy. 8.
Lordship, this is also referred in a judgment of Honorable Supreme Court and Omodando Kumar Pandey. On 108 is discussed. Then language is there. A subordinate officer, under officer, or other enrolled person. I am enrolled person. Which incurred 4 or more red ink entries. May be recommended. Maybe. Word is used. Maybe. Not mandatory. For discharge from service on ground of unsuitability, subject to the following conditions. These are conditions. After an individual has earned 3 red ink entries, he shall be warned in writing that his service will be liable to be terminated. Yes, they have complied this. If he earned 1 more red, it means on incurring 4 red ink entries, such a warning letter shall be issued to him by the concerned sector commander to the commandant of the individual. Okay. Then B, each case of the individual having earned 4 or more red ink entries shall be examined.
No. You see that in your representation, you have to explain where you have
Lord.
overstayed.
Lord.
You show your representation where you are given the reason.
He simply admitted that I may be pardoned.
No, you have to give a reason.
That is
You are in a armed force.
Lord.
Why? What reason you have given? You have not given any reason.
No reason. That
Then-
is, I do admit.
Then we cannot substitute. Take down.
He simply stated he is layman, the detective.
What can I do this? Take down. And you have not given any reason whatsoever.
Lordship. And submission is that they have not complied the procedural
They have
aspect.
complied with. They have examined and given a reason in terms of 108B.
And they have not considered what is the gravity. My case is that I have overstayed. And on 3rd and 4th and 5th, only 1 day and 6 days.
No, last time, how many days? Last time?
1
was
day,
there for how
only
many-
one. 1 day.
Last time it's only 1 day.
Only one, Lordship.
Last was 1 day, my lord. I prepared a brief synopsis.
If the last time is only 1 day, then
One.
My lord, that was extended because 4 action can be taken after 4 actions.
yes, no. In the fourth case, when he in the past 83 days, 84 days, he have condoned it, correct?
No.
So it's the fourth case. Fourth case, it says,
6 days, 4 days.
you please give me a chart. How many times he says? 2013, 28 days. 14 days. Again 18 days. So 3
No, my
is
lord, the leave is in the first column, my lord. That is the imprisonment given to him, my lord, that point of time.
75 days.
Yes, my lord. Then 7 days, then 63 days, then again 63 days, then 1 day, my lord.
Authorized was 63 days. Then absent without leave from transit camp.
I made done, my lord.
No, you think, just consider one thing. You are correct. But you see that for every offense he committed, he was not exonerated in that.
Yes.
He suffered imprisonment.
Yes.
So there is a punishment.
Yes. My lord.
If he suffered punishment
Yes.
for the same offense, then that cannot be again taken against him. That may be his past conduct, but he suffered. He suffered in one case 20 days rigorous imprisonment, another 14 days, another 28 days, another 7 days, and even for this 2023, for 1 day's absent, he suffered 2 days rigorous imprisonment.
Yes.
So gradually the number is decreasing. And you have to consider he is possibly a rifleman.
Yes.
He is not well equipped like you, him, or us on the day. He said, I have committed this mistake. So he is the only bread earner for the family. And this is only 1 day's thing he has done. So he says that after 4 or more rare entries shall be examined on its own merit,
Yes.
depending upon the nature of the gravity of the offence. Gravity of the offence is here only 1 day. And the aggravating circumstances under which these were committed. What are the aggravating circumstances? This you consider in the proper perspective. Past, yes. But for this 1 day, I think the punishment is disproportionate to the offence committed.
My lord, we took a liberal lenient view, my lord. Otherwise, he was liable only on 4th
No.
overstay, my lord.
If you have see, he has suffered also imprisonment.
My lord.
He also suffered imprisonment. So, earned 4 or more. This is the 5th one, I think.
This is the 5th one.
So, he earned 4 or more. So, this is the 5th one.
Yes.
So, gradually, his overstay is overstaying 63 days.
4th was 63 days, my lord. He was liable to be terminated that time itself, my lord. We gave one more chance, my lord. Then he disappears from the transit camp, my lord.
But for 1 day, will you just, if you have not done it for 63 days, for 1 day, will you? That's the question. If you have taken a view that overstaying 63 days and overstaying 1 day cannot be on the same platter, same page.
Lord, what I would submit, my lord, it's not the number of days, my lord.
No, I know.
Reading entry again, he incurs, my lord.
It's not the number of days, it's fine. But thing is this, that this is not the same thing as he committed a murder. He assaulted. He misbehaved. Act of insubordination. Misbehavior. Dereliction in duty in that.
But in those cases, there's a court martial, my lord.
I'm saying so.
Yes, my lord.
So here he was, and he suffered rigorous imprisonment. And then he was discharged. You consider this 1 day, see, 1 day, it's a transit camp. Absented without leave from transit camp for 1 day.
Yes.
He was on transit possibly.
Yes, my lord.
So he may be delayed by 1 day in the transit camp. You ask for an explanation that what is a delay for 1 day. And you revisit it. 1 day is delay.
My lord, what I would pray, will Lordship ask her to reconsider, my lord.
Sorry.
Lordship may pass an order to reconsider the matter, my lord. Pass a fresh order.
This is what we feel.
To give another SOCOS notice, my lord.
Thing is this.
Yes, my lord.
Clause A says only warning in writing, but you have given him imprisonment. Rule 108, discharge. You show us the rule which says that for this unauthorized leave, the regulations give you the power to give him punishment. He suffered a punishment. And punishment is rigorous imprisonment.
Yes, my lord.
Now, if you go by 108, discharge,
Yes, my lord.
it only says raiding entries he shall be warned in writing. There is no provision for him to be taken into custody or for any rigorous imprisonment.
My lord, here what happens, my lord? Whenever an offence under Assam Rifles Act is committed, my lord, your lordship is aware there are two kinds of offences in armed forces, my lord. One category is offences under the IPC, my lord, or general penal law, and other are offences which are not crime as such, but for armed personnel those become crime. Insubordination, overstay of leave, these become crime.
In military also, if you
Yes, my lord.
violate something, you may be given stand for 24 hours.
Yes, my lord.
Under the sun.
Yes. So those are not crime under IPC or any other law, my lord, but those are crimes under the Armed Forces Law, Army Act or Assam Rifles Act. Now, for these offences, he has been convicted and given the punishments.
No, I want to know from you,
My lord.
his rigorous imprisonment is under what provision of law?
These are under Section 11 of the Assam Rifles Act.
This shows Assam Rifle Act. Dismissal. We say that they suffer imprisonment. What is the provision for?
Yes, I'll point out. Just kindly give me 1 minute, my lord. I'll just point out. Section 26, my lord.
26.
B.
Persons who have performance in the form of say this. On conviction by the court. So there is an Assam Rifle Court. So his case he was convicted by the Assam Rifles Court.
Yes, my lord. But in fact, those
Item number 1.
Yes. Yes. Who is for the petitioner?
But here what happened, my lord? There's a military camp, my lord, in Shillong. So there are regimental shops which are leased out to civilians, my lord, in 2016-17, my lord. So two of those shops were given to them, my lord, for a period of shops, my lord, regimental shops for selling sweets, electronic shops, and for army people, my lord, within the regiment, in the army area. Now, my lord, if I may take your lordship's attention to page 16, my lord, this was the agreement, page 16. But period your lordship will see towards the bottom, 1 year from 1st April 15 till 31st March 16. Now, my lord, after 1 year was complete, they went and filed a suit, my lord.
No, which order you are challenging?
But order, I'm challenging the order that is at page 110, my lord.
110.
Yes, my lord.
It's an injunction petition.
Sort of injunction, my lord. Here, what happened, my lord, is some injunction was granted in their favor by civil court. Now, on a certain day, the interim order was not extended, my lord. If I may take your lordship to that particular
The
page, my
interim
lord,
order was not extended.
it was not extended, and on that day, somehow the army they vacated them, my lord. Then they filed an application under 151, my lord, for
They
restoration.
cannot. They cannot do it. That cannot be allowed.
My lord, I admit to that, my lord, but here what happened, my lord? The difficulty is, my lord,
No, whatever the difficulty is, this you cannot do it.
my lord, now at this stage, my lord, the
You
status
cannot
quo,
even do it.
but the status quo is directed
Status quo ante, of course.
in 23, my lord.
Of course.
Now here what happened, my lord, we have allotted the shops to the others, my lord.
You could not have. That's not done. They were, you may not be, it may not be a question of Order 39 Rule 2A, but it's certainly a question of propriety
That's true, my lord. I admit to that extent.
and how the army can do it.
But my
The
lord,
army
here,
can't do it.
my lord, here what happened, my lord, in the same military station, my lord, there are other shops occupied by them also, my lord. If I may take your lordship to one order passed by this honorable court,
That is not the point. That is not the point. For some days, status quo order was not there. Fine.
my lord.
Suppose think of a situation. They file a suit under Section 6 of the Specific Act. What would happen? Restoration immediately. And if they were able to establish a right when this interim order was passed,
Yes, my lord.
then you may have taken possession. There is a different issue. But if they establish that they have this was done unauthorizedly, you have been dispossessed.
My lord, my only case, my lord, is on the basis of page 127, my lord. Because for some shops, my lord, they filed civil suit. For some shops, they filed writ petition before this honorable court. The same party, my lord.
No, whatever is there. You cannot take possession. You can take possession in accordance with law, but you cannot take possession unauthorizedly by force of law. You take possession because ultimately you have dispossessed them. Correct? They were in possession.
Yes, my lord.
So dispossession without following authority of law is absolutely bad.
That's true, my lord. But your lordship kindly looks at the agreement, my lord. The agreement was only for 1 year, and they filed a civil suit without any basis, my lord.
Yes, which agreement you are showing?
Page 127.
Page 127.
Yes, ma'am.
It's an order.
Order passed with this honorable court in writ appeal.
Yes.
But here, what happened, my lord, in the neighboring shop, my lord, in the same cantonment, more or less similar process followed. Ma. Here, this honorable court also held that there is no equity in their favor, also, my lord, because they are given the shop only for 1 year. Maybe we are wrong in forcibly evicting them, my lord. So this honorable court directed to pay compensation of 10,000 rupees.
No, they were there for only 1 year.
Same respondent, they were having many shops in the cantonment in the regiment.
This Kushilla Chaudhary.
Yes, my lord.
So in respect of one of the shops, this is the order.
Yes, my lord. For one shop, they came to High Court, my lord. For 2 shops, they went and filed a civil suit. Shop number 16 and 17 are subject matter of civil suit, my lord.
Yes, what do you say? This order division bench
My lord,
at page 127.
is my lord, this order, my lord, perhaps would not help them in any way. And I say this for a reason, my lord, because this order, my lord, came to be passed because, my lord, because, my lord, there was no order by the civil court. In this particular case, my lord, there was no order from the civil court. In this particular case, my lord, which we are concerned now, my lord, there was an order of status quo by the civil court, my lord. My lord, may kindly see the order that the revisioner petitioner has assailed this before this honorable court, my lord. The order dated 31/1/2023, my lord. It is a very reasoned order. Your lordship is aware that, my lord, the powers of the honorable High Court under 227 is very limited, my lord. Unless they show that this order, my lord, suffers from any kind of perversity or my lord, the order is such that has led to a miscarriage of justice, my lord. There's order, my lord, cannot
Now,
be
this order was passed under section 151.
Yes,
right, my lord.
31st January order.
Yes.
Yes, my lord. Page 115, lordship will see, my lord. The cause of justice, page 115. The cause of justice calls for this court to exercise its power under 151.
My lord, I would like to go through this order, my lord. This is a very reasoned order, my
Just,
lord.
just.
Page 115.
Sorry, Mr. Mazir. Sorry. Ugly facts.
My lord, but only one aspect, my lord. So kindly consider, my
Play
lord.
down. No, sorry. Play down. This revision application is done.
My Lord, I am for the respondent. Before my learned friend starts, may I just take a liberty, my Lord, to pass on this judgment, my Lord. It's a decree, my Lord, passed by the trial court, my Lord, and then this has become infractious, my Lord. And
You are for the. You are for the.
I am for the respondent in the original plaintiff, my Lord, before the.
Now, who is the revision applicant?
He
I
is the
am.
revision applicant.
Is it infractuous now?
No, Your Honor. Why I'm saying that, Your Lordship, is that I've come before this honorable court challenging an order,
There is challenging an order
Lordship, which allowed the condonation of delay and substitution of the respondent as plaintiff in the title suit.
You are the plaintiff.
The respondent was the plaintiff.
So the learned judge allowed the application for
Condoning the
condonation of
delay
delay.
and the substitution of the
So you are
respondent.
challenging that.
Yes, I am challenging that.
So by that time the decree has been passed.
Yes, my Lord.
Yes,
So you can challenge this also in your decree, in the final decree.
Yes, yes.
Keep
that's
this
what I-
point. We can
Yes, that's
take
what
this
I meant.
point in your
my Lord.
in the decree also, because now that the decree has passed,
Yes.
you can take this point when you challenge the decree.
Yes.
yes.
If you file an appeal against the decree, all these points you'll be entitled to take all these points as a grounds of appeal.
Yes.
Yes, Your Lordship. But my contention is that
Because there was no stay.
No, there
So
was no
suit
stay.
has proceeded, huh?
No stay. No.
Suit for
My Lord, it was a suit for declaration of right, title, and ownership over a plot of land, my Lord.
take down. This revision application is arising out of an order dated 3rd May 2024. In connection with an application filed for condonation of delay in filing the application for substitution of the deceased plaintiff.
On behalf of the conducting counsel for the petitioner hearing, Your Lordship, I humbly pray for 2 weeks' time, Your Lordship, as the learned counsel is indisposed today.
Well, you are for the respondent.
For the petitioner, Your Lordship.
on the prayer of the learned counsel for the petition.